Ladies and gentlemen, welcome back to the IndieZoNe. My name is Kathy. November 5th, 2025 is a day when a restitution hearing has been scheduled to occur on the state of Idaho's motion and request before Judge Stephen J. Hippler in the high-profile case of State of Idaho versus Brian C. Kohberger, a case that had been active in terms of the criminal prosecution side of it from December 29th, 2022 through July 23rd, 2025. On July 23rd, 2025, after Mr. Kohberger exercised his right to enter pleas rather than go to trial in the case. There was a trial that was scheduled to occur in August of 2025. Instead, July 2nd, at a change of plea hearing, Mr. Kohberger pled guilty in open court to all 5 of the felonies that he was scheduled to stand trial on. There's a rule of court. It is a criminal rule in Idaho. It's called Rule 11, and it governs situations like this, where a defendant enters into a plea deal with the state in lieu of going to trial. After Mr. Kohberger entered his change of plea, there was a hearing that occurred on the 23rd of July, 2025. There were multiple things that happened that day. There were victim impact statements. There were statements that were made by the state of Idaho. Mr. Kohberger did not speak that day. He declined the opportunity to do so. And the court rendered certain rulings, which are essentially memorialized to writing in the judgment of conviction and commitment that was rendered that same day, July 23rd, 2025. And it began with the court noting that on July 23rd, 2025, William Thompson, Ashley Jennings, Joshua Hurwitz, Jeffrey Nye, and Madison Allen, counsel for the state of Idaho, and the defendant, Mr. Kohberger, with his counsel, Ann Taylor, Eliza Massoth, Jay Logston, and Bicca Barlow, appeared before the court for sentencing. The rest of the first page indicates that Mr. Kohberger was duly informed of the indictment returned against him for the crimes, and it goes into all 5 of the felonies that Mr. Kohberger was charged by indictment. This is what he was supposed to stand trial on. The issue of restitution is covered here in this document, the judgment of conviction and commitment. And it states here at the top of page number 4, the parties were not prepared to stipulate. That means to agree to. When you see that term stipulation or to stipulate, that means that the state and the defense have agreed to something that will not require court intervention to determine. Here, the court is stating the parties were not prepared to stipulate to restitution. The state is directed to notice restitution for hearing if the parties cannot stipulate to an amount within 60 days. This is the basis for this hearing on November 5th. It was the state who requested this restitution hearing, alleging that the parties could not stipulate to the amount within 60 days because this is what the court order said. However, if you go to the public docket and pull up the stipulation for restitution. It is dated August 27th, 2025, well within the 60-day period that Judge Hippler directed the parties were to stipulate to restitution, and if they could not stipulate, then to order the restitution hearing. This stipulation regarding restitution states that comes now the state of Idaho by and through the Latah County prosecuting attorney and the defendant by and through his attorney of record, and hereby stipulate to the entry of restitution orders herein as follows. And the first item is an amount payable to the Crime Victims Compensation Program. And we see the other two orders of restitution. We go on to the next page. There is nothing here that leaves this open for any other figures. It appears there's nothing here stating that there was anything else that still needed to be decided. It simply goes into the defendant further agrees to pay such restitution with interest at the judgment rate from the date of sentencing through the Ada County Court's clerk's office. And the date of sentencing was July 23rd, 2025, the same day that this issue of restitution was addressed by Judge Stephen J. Hippler. Now, this is signed by William W. Thompson, Jr., who is the lead prosecuting attorney for Latah County and the case, and Ann Taylor, attorney for the defendant. And this is dated the 26th of August, 2025. Now, if we fast forward, in September 22nd, was the first time that there appeared to be some sort of a disagreement regarding what had been agreed to when the state of Idaho then filed a notice regarding restitution, which did not go into very much why it was that, given the agreement that had been entered into, the state was looking for something further. The defense pointed out in their response in opposition, they said, look, we already have an agreement. The document that we just went over, and that's one of the bases, including several others, that the defense is disputing the payment of what they're calling additional restitution. The public got its answer why it is that the state is now seeking what the defense is calling additional restitution. We learn here state's response to defendant's objection to request for restitution that on page number 2, at the time of the plea agreement, the state was under the impression certain expenses incurred by the victims' families would be covered by the Crime Victims Compensation. After the sentencing hearing, the state was informed that the Crime Victims Compensation will not cover travel and lodging expenses for attendance of court proceedings, and on behalf of the victims, the state submits an itemization of expenses that were incurred by the victim's family, including expenses not covered by the Crime Victims Compensation for the court's consideration. And this is listed in State's Exhibit Number 1, which is under seal. There's 2 other documents that are also under seal that are referenced later in this documentation. At this point, it appears that it will be up to Judge Hippler to make this ruling of whether that August 27th agreement was binding if it can be reopened, basically, because of a mistake that was made by the state. If you have any comments, any thoughts, any opinions regarding this matter, please leave them here. And until next time, this is Kathy. Thank you for joining us here today.